Thank you.
Just briefly, very quickly, Judge. The argument that Mr. Gravely just made with regard to the reasonable person aspect of stalking only relates to element 2. That is, the course of conduct would have caused a reasonable person to either suffer serious emotional distress or to fear bodily injury, etc. But the important thing here is element 3 is that the defendant's acts did cause that person to actually suffer serious emotional distress, induce fear of bodily injury or death. So that's what we're missing here, is that there's been no evidence of that.
Well, again, the definition of suffer serious emotional distress, which is located in 2 and 3, is the same, which is harassed, which includes the subsection harassed.
And again, just briefly.
Well, no, that's your point. You're combining the act with the cause with the effect. You're merging them into one concept.
But the definition remains the same.
Oh, I'm not arguing that.
So yeah, you both have to, the conduct and the result, but the result is the result of the words suffer serious emotional distress can include that the individual involved feels harassed.
But that still doesn't cover both elements that we're talking about, 2 and 3. Really, well, logically speaking, the reason why element 2 exists is that we're adding a reasonable person standard on top of the actual causation that's represented in element 3. So presumably there could be a situation where somebody is overly sensitive and wouldn't be that reasonable person standard, which is why the state has to prove that additional aspect of it. But also, I think it's a leap to say that eavesdropping on somebody is harassment, and that's essentially what the state is saying. But checking in on the mother of your children and see what she's doing that doesn't rise to harassment necessarily.
I don't know about that. I'm not having such trouble, but I guess I think there's a step being skipped here. In merging the cause and the effect. The cause is harassing behavior by the defendant, and I think that there's evidence there from which the jury could conclude that element is present. The defendant's argument, as I understand it, is that where's the evidence that the defendant's acts had the effect of inflicting the
one of the subsections in 3 is caused Rosalio Gutierrez to suffer serious emotional distress.
right.
So yes. So the second element here is what would a reasonable person be feeling out of this, right? That's the second element. The third element is what did the named victim feel out of this? But the definition remains the same. That when you opt for to suffer serious emotional distress, whether you're speaking about the reasonable person or you're speaking about the victim themselves, right? It's still the same definition of suffer serious emotional distress. It's just all that happens in those change of elements is what would a reasonable person feel, and then what did the purported victim feel. In this case, the way you do that, you can't read the mind of individuals, right? We know this, right? In all instructions, it's from the acts and circumstances, particularly when you have a deceased person, right? So, otherwise you would never be able to stalk a person if you managed to murder them. You'd never be able to do it, right? So the third element here is what impact did this have on Rosalio Gutierrez? And within the definition of suffer serious emotional distress, one of the options is, did he feel harassed? Okay? So what is the element? What are the pieces of evidence he felt harassed? Well, he told an individual that he felt that this person was a problem. And if the court remembers, the court limited that evidence on various times. We described that we were wanting friends of Rosalio Gutierrez to talk about how he had identified an individual who was a problem for him. But we did manage to get one individual to be able to say that. And in their text messages back and forth, which were covered extensively, Judge, it's clear that Mr. Gutierrez is feeling harassed. And I told you, I think the most clear answer about that is the way he is planning on solving the issues that are related specifically is he's thinking, I will go over there. He does as much as collect the address of this individual. And I think that's the most rational and logical way that one would respond. So elements 2 and 3, the only change is what is a reasonable person going to be impacted, and then element 3 is how about the victim himself. But it's the same definition of suffer serious emotional distress. So certainly a reasonable jury could say, based on the facts we heard, Rosalio Gutierrez is someone specifically who would feel harassed here.
If I may.
Well, they didn't. The legislature did not use, or at least, this is the legislature. This language is taken from the law itself, not just a pattern instruction from the committee. But they didn't use the word annoyed.
Didn't use what word?
They didn't use the word annoyed.
No, they didn't. They chose harassed.
They chose intimidated, threatened, terrified, harassed, or tormented. Now, we had a case in here a couple of years ago. Not you, but a couple of people from your office, and the prosecutor. Well, all of our names who were involved in the case. Our addresses were published on the internet. My children's names were published on the internet. What the goofball thought were my children's addresses were put on the internet. All wrong. So I was annoyed. I cautioned my family. I made them aware of the situation, but in the case of at least one of your assistants, the correct information was published. And you know what he went through. I don't actually know what his reaction was. I know what a reasonable person would have felt. Terrified, intimidated, threatened, tormented, and harassed. That's what the reasonable person would have felt. And if you told me that he was any of those, I would say it makes sense to me. And I think the significant difference is that in my case, I knew the information was faulty, so I was still very annoyed, but I would not qualify myself as having fit into those categories. So it depends somewhat on the nature of the provocative behavior. And the question is not whether... there's. I won't talk about your assistant, or I won't talk about myself. But there are people who would react to that by searching the person out and beating the living daylights out of them. Happens all the time. That's our business, that we deal with these types of cases on a daily basis. So I'm not sure. Terrified, intimidated, threatened maybe, harassed, tormented.
This person was.
You're talking about now. We're not talking about the reasonable person. We're talking
I
about
understand.
Mr. Gutierrez, and if that element were written as being annoyed, I would quickly dispose of this motion.
He's peeped on twice. So within 3 weeks, he is inside the privacy of someone's home, their castle. Okay? And a person who does not have a right to look in the window, make observations, and then taunt individuals outside does those things, Judge. That's the allegation here. 2 separate times in 2 locations, he is eavesdropping on private conversations inside the home. This is I would say to you that's the definition of harassing someone. That is the definition of harassing someone. If somebody was outside your or my window when we were in the privacy of our own home, and they were then communicating to people that we were close to and saying, here's what I am observing in there. Here's what you just said inside your house.
Yeah, that would prove what a reasonable person's reaction would be.
But this is a deceased individual. So the court knows that those things occur.
I can't presuppose that, by the way. I'm not the jury.
We cannot look into the mind of an individual in this situation. We cannot do that. Except what I've told you already, what I've already shared with you, which is we've shared extensive email information back and forth where he and Sadie talk about how the stress of this particular experience, right? They're communicating about this. And Rosalio Gutierrez's reaction, shared with the jury, is, I think I'm going to take care of it. I think I'm going to go find this guy. I'm going to deal with him. And they even have a conversation revealed in the text messages about the address. So the court indicated, well, if someone shared your information on the internet, that might be your same situation. Yes. But the added information the court has is that what Rosalio Gutierrez knew at the time was that his information was he had been literally peeped on twice in private residences where then the information obtained in that peeping on him was being used to taunt people. And I'm not even talking about breaking in his vehicle, which of course is something that is a worry as well, private information. Right? So, for instance, what happens is a letter is taken from his vehicle, and that letter is utilized to try to indicate that Sadie should be watching out because he's actually in some other relationship. It's being used in a way to try to harm Mr. Gutierrez.
The statute deals with effect, not cause. You're talking about cause.
Right.
You're talking about effect on a reasonable person, and the motion, as I understand it, is the effect on Mr. Gutierrez. He's dying to talk again, so I'm going to let him.
And I'm being so patient, Judge, because I didn't want to interrupt Mr. Gravely. But I'll quote from a very significant text from Mr. Gutierrez. I'm not worried about it. That's exactly what he said. And the argument that one is guilty of stalking, and the most compelling proof of that is the fact that Mr. Gutierrez wanted to beat down Mr. Anderson. That's stalking. I mean, so that he had a reaction like, I want to take care of this, I want to deal with it, and simultaneously saying, I'm not really worried about it. I think the court's right. It may be something that one gets annoyed by, which is why I had the discussion about for something to rise to the level where it's criminal conduct, this type of criminal conduct, that it needs to be, an actual effect of harassment. And the most, I get a bunch of fancy arguments here about how, and again, he's focusing on reasonable persons, but we have evidence that it didn't bother Mr. Gutierrez from his own words, and in fact, one could glean that he almost found it amusing that he was going to break his legs or call somebody up to do something to him. But you can't prove that one's harassed because they want to beat you up.
Well, I think that I cannot, and I think this is the appropriate test. I can't exclude the possibility that the jurors will see it as Mr. Gravely does. and that a reasonable jury could come to that conclusion. When you use the word terrified, as the statute does, that kind of shoves aside a reaction like, I'm going to go confront the guy, and I'll take care of this. That to me is more the reaction of an annoyed person rather than a terrified one. But it's not. I'm not so sure of that I would grab the issue away from the jury. So I'm going to deny your motion.
Right. And just so the court, the subsection says or. What? So terrified is one. But thank you.
Yeah, wrong way.
Thank you.
I just think the court denies my motion, but he still has to add something to it.
Well,
We're done.
Now, come on, now let's play nice.
It's fine.
And your other motion with respect to the fourth count, did you make some comment on that?
With the hiding corpse,
Yeah.
very simply that we don't have a corpse, and I know we don't have to have one, but the evidence of again the aspects of that. Similar to count 3, I simply asked the court to analyze the evidence as to what evidence there is that a reasonable jury could find that Mr. Anderson himself, as opposed to anybody else, hit a corpse with the intent to avoid apprehension for a crime. And I acknowledge that if there is a corpse, if there is a death, which I know that the state has to prove that as part of this, but even supposing that, I'd ask the court to make that determination. I'm required to make the motion in any event.
Well, if the jury is satisfied of the state's proof on count 3, then there was a body, and it's gone, and there's evidence from which the jury could conclude that it was the act of the defendant that led to the removal of the body. So, motion is denied. What else?
I think that the defense wanted to just inform the court of where we are witness-wise for the remainder of the day. There was a development where the state had talked to an individual, and that nixed the necessity of 3 witnesses we had lined up for this afternoon. So now, instead of having 6 witnesses for this afternoon, the defense